Welcome back, everybody. This video is about a community town hall meeting. This video gets kind of crazy. People are very upset at this meeting. I believe that this was a publicity stunt by Alaska Attorney General Treg Taylor. This is going to be a two-part video because it was over 2.5 hours long. Let's get into it. I'm going to play you guys a couple of clips of what's in this video.
We're not going to stand for it. That Constitution is in Article 1, which is the people's rights. It's not in the executive branch. It's not. That's the hard facts. We don't trust you. Not on my watch are you going to give the grand jury independent counsel, because we have hard proof that you will not. You will lie to us. So, again, you're not doing it on my watch.
This is not right, Treg, and you know it. And I gave you option. Get the troopers, go get that report, and file against it. You could have done it in December. You held us off on our petition for how many months now? I am a petitioner. And you haven't even read my petition, I bet. And it's not just me. It's that gentleman and another lady in Anchorage.
He knows he's right.
He knows it. And I just read you a letter today.
Sir, one of the things I swear to do...
I'm going to walk out of here because you're politicizing this. You're not carrying out our constitutional protections under the Constitution. And you're a derelict of your duty.
Whatever, whatever affects one directly affects all indirectly. In December 2017, I observed David Haig being tased in a courtroom while the judge stood on his lofty perch.
No! Oh my God! Oh my God!
Wow, you guys see this? He's just standing there like he's enjoying it. Yeah, that's the judge.
Stop! Oh my God! Stop! Judge, you need to stop this right now! Stop this right now! Stop it!
The incident reminded me of King's comments about public safety and welfare.
Let's get into the video.
Mr. Haig, do you have a question?
I do, but it's sort of weaved into like some testimony. I thought I had 5 minutes, so it's kind of a combination, if that's okay.
Sure.
First, I'd like to thank Mayor Mchicki and Attorney General Treg Taylor and Ann Helzer for coming down. My name's David Haig. I testified twice to the 2022 Kenai grand jury that wasn't investigating Judge Murphy. They were investigating a lady by the name of Marla Greenstein for falsifying official investigations to cover up for corrupt judges and keep them on the bench, and whether or not the Department of Law was covering that up. I'm going to go over facts which are in conflict with each other, mostly regarding SCO 1993, which is the Supreme Court order, and the Department of Law's new process. After I'm done, I would like Attorney General Taylor to explain and resolve these conflicts and tell us why and how the Alaska Supreme Court and Department of Law are not violating constitutional rights. SCO 1993 and the new DOL process positively states that citizens cannot appeal directly to the grand jury. The problem with that is the 55 delegates who wrote our Constitution said this specifically without a single voice in dissent. The grand jury can be appealed to directly, which is an invaluable right to the citizen. There is no getting around that. We are not going to be kept away from the grand jury. No one is going to be the gatekeeper. I'm sorry to say, you seem like a nice guy. You are not going to be the gatekeeper, period. Not on my watch. SCO 1993, the new DOL process, state that only issues affecting many people can be given to the grand jury, and no court case, either open or closed, can be given to the grand jury. But this conflicts with what the 55 delegates who wrote our Constitution stated without a single dissent. And this is what they stated. The grand jury, first they said this issue can be utterly vital to the citizen. The grand jury essentially is an added protection to the citizens, specifically to criminal cases. The grand jury, in its investigative power, as well as for the fact it is sitting there as a panel, sometimes is the only recourse for a citizen, to get justice, to get redress from abuse in lower courts. It is the only safeguard a citizen occasionally has when for any reason, and very often for political reasons, a case is not dealt with properly. I am not going to let you bar individual citizens from appealing to the grand jury. Not on my watch.
I will.
Okay, you talked a great length about the independent counsel that we're going to trust you to provide to these grand juries. The Kenai grand jury apparently got rid of the Department of Law attorney advising them, a lady by the name of Jenna Grunstein, and asked for independent counsel. And they were provided with Clint Campion. I asked Mr. Campion how he was selected and why he never told the grand jury that when he used to work for the Department of Law as their chief assistant attorney general, he investigated all of the allegations, criminal allegations against Marla Greenstein, and absolved her of everything. How would it look if the grand jury found criminal conduct against Marla Greenstein when Clint Campion had exonerated her? He had an overwhelming, a compelling reason to make sure the grand jury never found anything. That's the hard facts. We don't trust you. Not on my watch are you going to give the grand jury independent counsel, because we have hard proof that you will not. You will lie to us. So, again, you're not doing it on my watch. As far as whether this is constitutional, what is going on with Supreme Court 1993, which amends Rule 6.1 to make it far worse. Back when Rule 6.1 was first implemented, there were 5 Supreme Court justices, just like there are today. They had a dispute over whether Rule 6.1 was constitutional. 2 of the 5 justices said it was blatantly unconstitutional, and in fact, trying to find my notes here, this is what they said. So this is how all this came to be. 5 judges, 2 of them said it's blatantly, but the 3 overruled the 5, or the other 2. This is what the 2 said. Criminal Rule 6.1, adopted by this court pursuant to its rulemaking authority, not only suspends the power of grand juries to investigate and make recommendations concerning the public welfare or safety, but also permits censorship of a grand jury report generated as a result of that power before the report is even published. That is exactly where we're at today. They knew what was coming down the pike. This is the Supreme Court justices. This rule is not the least bit deferential to the anti-suspension clause. Indeed, it mocks it. The grand jury, and not the courts, can choose matters on which it reports and recommends and the manner in which to do so. Criminal Rule 6.1 violates the anti-suspension clause of Article 1, Section 8 of the Alaska Constitution. That was before SCO 1993 made Rule 6.1 an order of magnitude worse. We're not going to stand for it. That Constitution is in Article 1, which is the people's rights. It's not in the executive branch. It's not in the judicial branch, or it ain't in the the legislative. Anyway, and just you can shut me down when I run out of my 5 minutes here. Well, and the justices said why they had to make these statements. A grand jury had investigated a guy by the name of William Sheffield for steering a $10 million lease to a campaign contributor, and a grand jury investigated, and they not only investigated, they recommended to the Alaska legislature to commence impeachment proceedings. And the judge that got the report, he said he had no right to not make that report public. That is how it's supposed to be. Those judges, we don't have to do anything. You know, these new things are wrong, and the history shows it. And so we just have to go back and look at that. And again, look at what happened at the Kenai grand jury report. And doesn't it seem a little odd that the Kenai grand jury was investigating whether or not there's systemic corruption, that for possibly 36 years Marla Greenstein has been falsifying investigations to cover up for judges, and judges step in and seal it? That ain't happening here. We still live in America. We're going to put our foot down so hard. And yeah, you may drag it out for another year, maybe even 2, but by the time we get angry enough, you're going to see something awesome. The whole world's going to see something awesome here. As far as you saying there was no established procedures for grand juries, this here is the original Alaska Grand Jury Handbook, published by the Supreme Court of Alaska. I'm going to just read 2 lines out of it. Charges of crime may be brought to your attention in several ways. Number 4, by private citizens heard by the grand jury in formal session with the grand jury's consent, not your consent.
Amen.
Another line, a citizen is at liberty to apply to the grand jury for permission to appear before it in order to suggest or urge that a certain situation should be investigated by it. Again, apply to the grand jury. We don't apply to Ann. We don't apply to Treg. We don't apply to anybody but the grand jury. Because again, if in fact you and the Department of Law are part of the problem when you're the gatekeeper, I don't think this needs to go to the grand jury. My name's on it. I mean, it ain't happening. Simply is not happening.
David, you're on your third 5-minute period, but just think about that as you go forward.
I'm down to what?
You're on your third 5-minute period.
Okay, well, I have one last thing here, I guess. In SCO 1993, in your new process, it says basically investigative grand juries will only be impaneled after the Department of Law decides there should be one. In the original, this is the transcript of the delegates. They knew that wouldn't work. And they said this. They said, they were discussing it, exactly what you now have. And they said, however, an investigative grand jury will only be called under certain specific circumstances. That's exactly what your whole process is. And somebody is going to have to find conditions pretty bad before an investigative grand jury will be called. Whereas a grand jury which is impaneled regularly, and you could tell me right now, how many grand juries are impaneled? 0? Or about 20? Right now, right here now.
There's a grand jury impaneled in every separate jurisdiction within the state as we speak.
Yeah, and there's multiple ones in Anchorage, correct?
Yes, we do have a high caseload.
Okay, so they're saying a grand jury which is impaneled regularly has full investigative power as well as power to consider indictments. The grand jury is there and may take any steps it feels that may be necessary toward an investigation. It does not have to wait for a call. So that's it. I thank you very much, but if you think this is going away, think again.
No, I know it's David, I really appreciate your comments. We agree on more than you think we agree on here. Your last comment, for example. Yeah, any grand jury right now in the state, if a juror brings up an issue and the grand jury decides to investigate that complaint will move forward with an investigative grand jury. And so that's been the case. That's always been sort of the way that you do this. I love the fact that you use this old handbook because it does point out some differences between what happens now and what happens later.
Yeah, but Mr. Taylor, you're wrong. It isn't an individual grand juror. It's the public, the citizens.
Can you let him finish and then?
Yeah, okay.
Please.
Let me address that a little bit. And the Constitution reads this. It says the power of grand juries to investigate and make recommendations covering concerning the public welfare and safety shall be suspended. Who has the power there in that Constitution? It's the grand jury. The grand jury decides who's going to come before it, what evidence they're going to hear, and if they're going to move forward. The power, as I said earlier in my statements, the power under the Constitution is with that grand jury. I love the fact that you hold up that old handbook. We looked at that many times trying to figure out what the process used to be like. Unfortunately, the handbook doesn't really talk about a process. You talked about a couple things in there. Let me address them. You said the grand jury is there and may take any steps that it feels to be necessary toward investigation. It doesn't have to wait for the call. So the grand jury doesn't have to wait for the call. And then the next part that you read in that grand jury handbook is this. It says, a citizen is at liberty to apply to the grand jury for permission to appear before it. Again, the power is with the grand jury. What we've never had written for the whole world to see is a process for how that individual applies to a grand jury. Right? Now we do have a process for how to apply to the grand jury. And I want to address some other things that we agree on. Independent counsel. You're right, there's problems with the independent counsel model. I am fully aware of that. And it's hard, you can appreciate this, David, that it is hard to find independent counsel willing to take these cases on.
Can I jump in here for a second? In the
Sheffield. Can I respond to your comments first, please? It is exceedingly hard to find independent counsel that is willing to take these issues on, for obvious reason. Because if a grand jury does not go the way that the person who wants the grand jury to go, that individual is now part of the corruption and part of the system.
Exactly.
And no independent attorney that I can pay on contract wants to put themselves in that way. They have families. They don't want to be in articles all over the state as being corrupt. So it's really hard for me to find people that are willing to take these cases on. Now we've managed to find a couple, and like I said, we have one that has allegations of corruption throughout the Department of Law. That is, we have this person selected to take that case on, and by the way, luckily we were able to find someone that has never worked at the Department of Law. That's pretty rare.
Okay.
And so that investigative grand jury would be moved on. So that addresses the independent. The grand jury reports. I completely agree with you. The court has no business determining what report goes to the public and what report does not. That is up to the grand jury. And so I think that's one area where the court got it wrong. They should not. They should not have to submit their report to a court and ask for the permission to be published. I 100% agree with that. And like I said, I wish that prior report had been issued. And then, again, there's despite the rules and despite the problems, I think we're more transparent with this process than we've ever been in the state. Because A, I can indicate what issue is being investigated, whether or not it went to a grand jury, and I can also point to whether or not a public report was issued. So at least the public knows this issue, allegation of corruption, went to this individual, went to a grand jury, and then people can, if the grand jury chooses not to issue a report, or a court, again, doesn't allow the report to come out, that's going to be noted in the file. So that's really transparent. Before that never could occur because all that occurred within a confidential grand jury process. Not even the grand jurors are allowed to go out and talk about what happens in the grand jury. That's pretty standard everywhere you go in the world. And then so we agree, David, on more things than you think. And I agree that there's still changes to be made. Again, in our facts, we point out again, this is the first iteration. We're still trying to figure out a better way to do this because we want the public to have confidence in the system, right? One of those ways is through a legislative fix, right? So talk to your legislators. I don't mean to throw them under the bus, but they can enact legislation that takes it out of my hands. I would love for that to happen because the last thing I need is somebody that thinks I'm corrupt because a grand jury didn't take up an issue. I think that's not in my best interest. And the last thing I want to know, the last thing I want is for there to be corruption within my department and me not be aware of it, and it never sees the light of day, right? So we agree on more than you think, Dan.
Okay. We asked many times in letters for a meeting with you to give you hard evidence of corruption in your Deputy Attorney General, John Skidmore. A grand juror, former grand juror, is here today that Mr. Skidmore falsified what occurred in his grand jury to Mr. Machicki was there as a senator, and our Speaker of the House, Mike Chenault, was there, and his statements are false or a lie or whatever you want to call them to justify John Skidmore walked in and stopped a sitting grand juror from talking to his fellow grand jurors about crimes. And our statutes in this state say an individual grand juror who has no reason or who knows or has reason to believe a crime has been committed shall inform his fellow grand jurors who shall investigate.
Hey, David, please submit this.
I have how many times?
Have you
Hundreds.
submitted it through this process? David, look, I'm telling you right now, David, if you submit that claim,
That's been submitted.
I will push it to a grand jury.
Hey,
Okay,
guys,
I'll-
we're not,
I'll
we're
try
not
again.
gonna do
And-
this.
So
And I
what
wanted
I want
to,
to say, David, is this: if you submit that complaint and the hard evidence that you have as the gatekeeper, and again, I don't want to be the gatekeeper. Let me make that clear. I don't think I have any business being the gatekeeper. But as the gatekeeper, I will push that to an independent prosecutor for investigation by a grand jury. You have my word on that, David.
Yeah.
And it'll be public that I did or did not do it, because I'll put it right on the website that it went to an investigative grand jury.
and you know what?
Do that, you already know the information.
Yeah, why don't you do it?
David, do you have any more questions?
Well, I just want to answer one of those things. He asked where they get independent counsel. I'll tell you what happened in the Sheffield case. Huge case. Governor going down. I mean, they wanted to charge him with perjury, and the independent prosecutor says, we don't know whether we can do that with a sitting governor. Their counsel came from Washington, D.C., and both of the opposing attorneys were former Watergate attorneys. That's what should have happened. So, thanks.
I'm gonna call folks as they signed up in order, if you don't mind, if that's okay. Mr. Hartring, you're next. I won't start your 3 minutes until after you start talking.
Thank you, Mr. Mayor. For the record, Jim Harpering, Waterfront Way, Funny River Road. I've been following this now for this entire process for going on probably 15 years. And I've tried to stay at the arm's length from it, even with David living as a neighbor down the road. The issue here, though, is one of improprieties alleged, improprieties proven, and the system itself. And after talking to David again today, I was on the talk show with Bob Bird, a very hostess here, and this is the second time. The first one was on the 16th of July when you released the press release. And we went line by line, and I gave my opinion on each one. We reiterated those lines today, and with ending this evening's meeting. After looking at this and very diligently looking at it, looking at other states in my old life, and I'm retired now, and just kind of feeble. But the issue here is I believe that there's a meeting, and I talked to David, and with his permission, I'll go down this route. This is as late as 10 hours ago, that there's a possibility with your projected concept of how it to work, and my understanding of how I would see the ideal world work, that maybe we can come to a meeting of minds and everybody can come out not a winner or a loser, but with a system that works. And that's all I'm going to say. And that would consider, and I know you're going to go fall out of your chair, so brace yourself. And this would be through a consent decree. And if we have a consent decree where we are preceded by an MOU, MOA with the parties involved. So everybody understands what the goal is, and the consent decree then would allow for a finding of how the system can be improved, that is totally independent. And I go back to where it's been successful: Memphis, Tennessee, New Orleans, Louisiana, Minneapolis, St. Paul. I mean, I can go case by case by case and spend the next 6 hours in here and articulate it. But if you would consider that, I think I can really put a package together And again, I bless this with David. David, you agree that
It's a potential solution.
in
Consent decree governed by the federal government.
for a time element specific to the agreement that the parties aggrieved are concerned, and it's made public. It isn't something that we're going to hokey pokey around with this thing. There's a site. The site can be monitored. The site can be updated, and the progress made by that concept. And I've got a lot of other notes, but after David's excellent presentation here, I'm just going to let it go. And unless there's questions, I'll return to my seat.
No, I really appreciate that, and I just want to comment just briefly on that. Yeah, if the federal government or federal prosecutors or U.S. Attorney's Office, I think there's easier ways to solve this, and I think it's through our legislature. And I think and I think there's. So I've gone around and around. Like, do we impanel a commission to do this? Do we put like 5 people on a commission that look at these things? I'm just not in the way the current rules are. It's almost an unworkable solution. One of the things that could happen is that report. So one of the reasons I wanted to make sure we publish the process is because I want people to be able to challenge that process. Now, it's sort of a circular solution, right? How do you challenge that process? Well, you sue me in the courts, right? The courts came up with the rules. But another solution is challenge me in an investigative grand jury on that process and have a report from an investigative grand jury. A grand jury investigated to look at the issues, what the Constitution requires, whether we're meeting the constitutional requirements of that, whether the court is meeting the constitutional requirements of that, and then they can push out a public report. Right?
Yes, back to one follow-on question to your response there. The 3 elements that constitute a grand jury's necessity to meet don't meet those with we're going to investigate that element of it. And again, I go back to solve to resolve this, for everybody can believe in the process. And that's why I can talk to David for over 45 minutes today on it again. And I think we really can do it.
Yeah.
And again,
I think this is a starting place, right? This is a place that we can start.
At least the dialogue.
Discussions.
At least the dialogue's there.
Yeah.
The information that we provided was overwhelming. That there is corruption in our judicial system. If the plan that you presented tonight is what you gleaned from the information that was presented at that meeting, you didn't read the information. So why should David Haig have to present it again? He has presented it numerous times.
And other people's one.
And that's all I need to say.
First of all, public trust is at an all-time low, and we got to do something about that. So we're gonna let most things through it, unless it's an obvious. When I say I'm still gonna be a gatekeeper, yeah, probably. Like if it's a property dispute, like we talked about before, I'm gonna say, kindly, this is not the forum to address a property dispute. Now, if it's a widespread property dispute with all the residents against a utility, well, there you go. That might be something that investigative grand jury can look through. But like I said, we've already had one come before us through the process, and we've pushed that out to an independent prosecutor. And I think there has to be a process, right? I think everybody deep down kind of understands that the process A is one controlled by a grand jury, not by individuals. And so even the stuff that David Haig mentioned, where the person, let me read it again. The power of grand juries is what's used in the Constitution, and this is in the first handbook. So this is the very first Supreme Court came up with this. So they were part of that whole constitutional process. And in there they said the citizen is at liberty to apply to the grand jury for permission to appear before it. Right? There's this process. What is that process? We've attempted to come up with a process that also complies with the court rules. Like I said, I'm not a fan of some of the portions of that court rules, and I can't do anything to change that other than to make a public comment, maybe put pressure on them, to sort of change those rules. Because the last thing I want to be is this in this position. It's an unfunded mandate from the courts. We're taxed as a department already in trying to prosecute crime, trying to deal with all the litigation issues we have against the federal government right now. So we're taxed already with our budget. So the fact that now it's my budget going out to fund these, and it's an important process. It's important. It should be funded. The question is, where should that funding come from? And I didn't get any additional funding for this. So all of these outside contracts with attorneys that are fairly expensive cost the budget. And I'm not complaining about that. I'm just going to further show the problems with the current process.
So if the website is in itself kind of a measure or a means by which to hone down and provide a quantitative methodology for the Department of Law to filter out maybe things that would be superfluous or unnecessary, things that would get dismissed. So it's like I said, a quantitative methodology for the Department of Law to get cases. Is on the other side of that, is there a quantitative methodology by which it can be objectively stated which cases would or would not go to a grand jury? Does that make sense? Like, rather than it being somewhat subjective still, even though there is kind of a process now in place, is there an objective way that can be, people can have some assurance of that, I guess is where I'm going.
Yeah, public welfare, public safety, pretty nebulous, right? And the courts put some guardrails on it, but again, people are going to rebuff against even guardrails, right? Because everybody's going to think, what does public welfare, what does public safety really mean in the terms of an investigative grand jury? And there's one of your problems right there. And so when the court put guardrails on it, rightly so, people were upset with those guardrails. When the court put sort of the process being, it goes to the Attorney General's office, people are upset with that process. But we're talking about it. That's the big step, is people are aware of it. And again, one of the reasons I was really adamant, trust me, I got pushback for creating a process for it. I got pushback a lot for wanting to put it out on the internet for everybody to see, because they had fears that the process would be abused and all this stuff. And I wanted it to be the most transparent process ever. Everybody knows exactly what needs to be done. And it's public whether or not it goes to an investigative grand jury. That's huge. Like if we outline an allegation against this department, it went to a grand jury and did not result in a public court. Well, that's more transparent than we've ever had in the state.
It's not constitutional though.
Sir, I don't control the rules of the court.
You can challenge them though.
Yeah.
By we the people's
Fine.
rights to
Okay,
define
next
us.
up, Mr. Southwell, please, it's your turn.
This is not right, Treg, and you know it, and I gave you option. Get the troopers, go get that report, and file against it. You could have done it in December. You held us off on our petition for how many months now? I am a petitioner. And you haven't even read my petition, I bet. And it's
Mr.
not just
Southwell.
me, it's that gentleman and another lady in Anchorage.
He knows he's right.
He knows it. And I just read you the letter today.
Sir, one of the things I swear to
I'm
do.
gonna walk out of here
is-
because you're politicizing this. You're not carrying out our constitutional protections under the Constitution, and you're a derelict of your duty.
Welcome to Soldotna, Mr. Taylor.
Bravo. And you guys hear the mayor? Welcome to Soldotna, Taylor. Like it's a joke. Absolutely disgusting.
Next up is Mr. Southwell.
I am Ray Southwell. I'm going to share with you my experience on the grand jury 7 years ago. But before I do that, I'd like to make a quote from Martin Luther King Jr. as he sat in jail in 1963. Injustice anywhere is a threat to justice everywhere. We are caught in an inescapable network of mutuality, tied by a garment of destiny. Whatever affects one directly affects all indirectly. In December 2017, I observed David Haig being tased in a courtroom while the judge stood on his lofty perch.
No! Oh my God! Oh my God!
Wow. You guys see this? He's just standing there like he's enjoying it. Yeah, that's the judge.
Stop! Oh my God! Stop! Stop! Judge, you you need to stop this right now! Stop it! Stop it!
The incident reminded me of King's comments about public safety and welfare. In January of 2018, I was a member of the grand jury. The local judge encouraged us to read the grand jury handbook, and I diligently studied it. By mid-February, it became evident that I had a lawful responsibility and right to share information with my fellow jurors regarding public safety and welfare. I developed a plan to accomplish this. On March 7th, 2018, I began discussing my plan with my fellow jurors. As I spoke, I noticed the deputy clerk turn off the recording device. Knowing the court rules, I instructed her to turn it back on. She eventually complied, and I continued sharing my thoughts. I intended to present evidence of the crimes to my fellow grand jurors on March 21st, 2018. I sent a memo to Judge Wells requesting assistance with this process, but she refused. On my next grand jury day, March 14th, 2018, I reiterated my plan. On both occasions, two different assistant district attorneys informed me that I could not bring such evidence. I was aware that they lacked the authority to prevent me from doing so. On March 21st, I was prepared with witnesses in the courthouse and had my written documentation. This time, the Kenai district attorney was present. He objected to my plan. I distributed a proposed report to my fellow jurors and went to retrieve my first witness. Upon returning with my first witness, I discovered the DA collecting the handouts and informing me that we needed to discuss my plan with Judge Wells. During the recorded hearing, I presented my thoughts to Judge Wells. On the phone, representing the state district attorneys, was John Skidmore, who was then the director of Alaska Department of Criminal Law. Judge Wells presented me with two options: dismissal from my grand jury or silence. I chose the latter. Grand jury understanding expanded over the following months and years. By 2022, 3 persistent individuals were compelling judges to permit such investigations. The court system sought guidance from its fixer, John Skidmore. Since our interaction, he has been promoted to Deputy Attorney General. Examining the available public documents and applying logical reasoning, it becomes evident that John Skidmore authored Supreme Court Order 1993. The Supreme Court was apprehensive about 3 persistent individuals advocating for grand jury investigations and hastily approved the change without thorough review. This order effectively halted the process of these 3 persistent individuals. I will conclude with this. My experience and my observations. When civil justice fails, street justice explodes, disrupting public safety and welfare, as Martin Luther King Jr. aptly understood. And I appreciate you listening. Good eye contact. Thank you.
Thank you for your comments, and it reminds me of one of the projects that you'll soon see also on the website, because what we have now addresses when you apply to a grand jury, right, for application. What we don't have that's public is the procedure to be followed when a grand juror themselves requests an investigation. And so that's my aim in the next couple of months, is to put that and make that public exactly. Because what we have is you have prosecutors, right? They're in a grand jury room. They're there to indict criminal cases. That's all they've ever done their entire career. In fact, they've indicted probably thousands of criminal cases. And when a grand juror raises their hand and says, "I have an investigation that I'd like to conduct," their mouth sort of drop open and they go, "I don't know how to do that." But we've provided some training, and now we're going to come and we're going to publish the procedures that those prosecutors will follow when a grand juror on a criminal indictment says, I have an investigation, I'd like to proceed. We'll make that public, so what the process, and then all prosecutors will be held to that procedure. And I think that'll help. Again, my aim is to make this as transparent as possible under the current court rules that we're bound by.
It's still unconstitutional.
Thank you. Ms. Reveal, please.
Thank you all for coming. I so appreciate you guys being here. I'll introduce myself really quickly here. My name's Jean Reveal. I'm a former law enforcement officer, investigator, and deputy coroner. I recently got an opportunity to watch the district attorney's office in action.
Okay, I'm going to stop it right here. I'm going to do a part 2. It's not over. There's a lot more going on here. This lady is an ex-police officer. We got an FBI agent that comes in and testifies and much more. Oh yeah, update since I'm editing this, August 21st, 2025. Treg Taylor has resigned. Do me a favor, like, share, subscribe, leave a comment down below, and I'll see you guys on the next one. Later.